So by now you probably heard that the Karen Reed hearing that was supposed to happen today did not happen. So let's talk about some of the filings that happened specifically yesterday and what we're doing moving forward. And this one has to do with the Michael Proctor subpoena. So let's go over that and why he is objecting to turning over his phone records and supporting the Norfolk County DA's office opposition to turning over those records. Okay, so just in case you forgot, Stephanie, criminal defense attorney, season 3, Karen Reed. We're loving it. Awesome, super fun. So let's go over the document. So this was filed by, I'm assuming, Michael Proctor's attorney. It's a third-party Michael Proctor statement in support of the Norfolk County DA's office opposition to the defendant Karen Reed's motion to compel protection of data. So full-on mouthful, okay? But essentially, this is what it is. All right, I'm just gonna give you the summary. All right, they want, I'm talking about down here, Reed and her attorneys are already in possession of at least 38,707 pages of text messages from Proctor's personal cell phone. Now, that is a shit ton of, that's a legal term, by the way, shit ton of text messages from Proctor, okay? Reed's motion seeks previously disclosed and widely publicized text messages sent by Proctor with an assumption that there are others, okay, that were subpoenaed by a federal grand jury pursuant to an investigation into the Massachusetts Police's involvement into the criminal investigation and prosecution of defendant Reed, and included Proctor's personal text messages sent both before and well after the state's grand jury's June 9, 2022 indictment of Ms. Reed on second-degree murder charges. Importantly, contents of Proctor's cell phone are currently under a December 10th, 2025 protective order in the Miles King case, all right? Basically, they're saying that they don't have to turn this over, all right? And we're going to get into their argument. So attorneys like to throw out overbroad and vague a lot, and that's sort of what his attorneys are saying here. Be more specific. Be more specific about what you want, because right now you're just telling me we want everything that's ever been on his phone, and that's really broad in scope and in time, and we're not going to do that, okay? Also, they're arguing that there's confidential conversations with his attorney, as well as his spousal communications, which are protected by law. This is the part that really got me, is that the attorney files this, and then he says the undersigned counsel has not seen the scores of thousands of documents, text, emails, messages, and other items contained within the electronically stored data. So he's basically filing this and being like, I have no idea what is on here. I haven't looked at it yet. So I'm not really entirely sure how he could file this, or they could file this and then be like, we object, but we don't know what's on there, because how do you know if it's relevant or not relevant? How are you objecting to the relevance and the broadness of the vagueness and the scope of this if you don't even know if there's anything on there that's relevant? So that's a little disingenuous to me personally. And then they go down there and they're down in the bottom and they're like, it's privileged, it's medical data, that violates HIPAA, which really doesn't, but that's a completely separate issue. I also, you probably can't see it, I'm going back a page, but on the bottom in footnote 2, it says, to the extent Reed asserts that Proctor and his attorney should be forced to review the data for these privileges, such a request is overly burdensome. Overly broad and unduly burdensome. Okay? So they're basically saying, we don't want to do our job. We don't want to do our job, it's too much work. So essentially, in a nutshell, Proctor's attorneys are arguing that A, it's too much work for them to go through everything. 2, it's going to be well over, they say in there, 100,000 pages of text messages, which I'm not sure how they can argue when they haven't looked at it and they admit that they haven't looked at it and they don't know what's on the phone. But in general, that is an opposition that was filed yesterday. So that is one of the reasons that the case was adjourned today. There are others, and we'll go over that in a separate video, but I wanted to show you guys that motion because Proctor's being Proctor as usual, and it's shady, and I'm here for it. So let's see how they respond. All right, so let's get to it, and we'll talk more about the other reasons in a little bit. All right, so check it. I lost my train of thought, but check us out on live. All right, we'll see you guys later. Bye.